Affirmative. Resolve that the USFG should require that minors receive parental consent prior to having an abortion. Observation 1. Inherency. Minors have a need for parental guidance when it comes to decision-making. Limiting parental consent will lead to inadequate decision-making of minors and making the right appropriate decision. A. Minors don't have the maturity to make decisions or understand the risk of an abortion. Because the U.S. Supreme Court has ruled that states may not give parents an absolute veto over their daughter's decision to have an abortion, most state parental involvement requirements include a judicial bypass procedure that allows a minor to receive a court approval for an abortion without her parents' knowledge and consent. Some states require judges to use specific criteria when determining whether to grant a waiver of parental involvement. These criteria can include the minor's intelligence, emotional stability, and understanding of the possible consequences of obtaining an abortion. Many states require a judge to use the unusually strict legal standard of clear and convincing evidence to determine whether a minor is sufficiently mature and the abortion is in her best interest prior to waiving the parental involvement requirement. Observation 2. The harms. A. Without parental consent, minors may not make the right decision medically and run into abortion complications. There are other inherent risks to surgical abortions such as uterine perforation, cervical lacerations, and hemorrhage, in addition to inherent risks of anesthesia. Other immediate risks include infection lessened by antibiotic coverage, retained intrauterine tissue, cervical incompetence, bowel perforation, and peritonitis, and pelvic pain. Those performing both medical and surgical abortions are warned of the risk of missing an ectopic pregnancy, which can prove fatal to the mother. Observation 3. The plan. Therefore, we present the following plan. The United States federal government should enforce the Sienna Abortion Act in all states to protect the health and safety of minors and protecting the rights of parents to be involved in the decision prior to an abortion. Observation 4. Solvency. A Child Interstate Abortion Notification Act in place in most states to protect the safety and health of young women. The proposed Child Interstate Abortion Notification Act is an appropriate and measured response to the limitations on states' powers in our federal system. It is grounded by the reality that parents are nearly always the first to help a teen in trouble, and that fact does not change when the trouble is an unplanned pregnancy. There is no other elective surgery that minors can obtain while keeping their parents in the dark, and the controversy surrounding this act shows just how severely the judicial creation of abortion rights has distorted American law.